Welcome to Protecting Your Legacy with Estate Planning.
Hey everybody, welcome back to an all-new episode of Protecting Your Legacy with Estate Planning with Adam Grant. I'm your host, Mike Leon. Adam here is the founding partner over at Stonewood Law PC in Encino, California. He's got over a decade of legal experience focusing on estate planning, probate, conservatorships, supplemental need trusts, and entertainment law. And he's known for a client-centered approach. He's been helping Southern California families protect what matters most and build lasting peace of mind for generations to come. Today's episode, we're going to be focused on conservatorships. Adam's going to walk us through what they are, when they're necessary, and how families can navigate them with compassion and clarity. Adam, it's good to see you as always. Let's start with the explainer part of this. Explain what a conservatorship is and when a family might need to consider one.
Yeah, thanks for having me, Mike. They are a very useful tool. Oftentimes you will see this when a client doesn't have a power of attorney in place, or if there's a disabled individual in their family, and this individual needs additional guidance and support. A conservatorship is a very arduous process, but it's cumbersome, involved, and timely for a good reason. Conservatorship takes away an individual's constitutional rights. So things like the ability to enter into contracts, enter into marriages, to vote. These are all a list of constitutional rights that someone can have taken away through the conservatorship process. So it's very important that you constrain or restrict the powers that you're seeking as conservatorship with your attorney, trying to understand what it is that you need for your family to care for this person. Do you need to make sure that they're not a harm to others and need to be put in a facility? Do you need to ensure that they take their medications every day? These are all powers you'll request from the court. And the court will determine based off independent investigators report and counsel, which is appointed through either the county or paid privately through the estate. There's court-appointed counsel for the client or for the conservatee in this case. That court-appointed counsel will make a recommendation, will look at the doctor files or declarations, and then make it a recommendation to the court. So with that recommendation, the court will ultimately decide which powers to give the conservator in this case, and perhaps it's two conservators, a team, and perhaps they have independent powers if they work together. But that conservator makes sure that this person has what they need, is not a danger to themselves, and that they can provide for their essential needs.
Let me ask you a little bit more on the process part of this. Who can file for a conservatorship in the state, and what does the court look at before making any type of decision?
So anyone who is essentially in the need of conservatorship are people who have a handicap, a disability, they're a harm to themselves or to others, 5150. There's a bunch of different scenarios where a conservatorship would be appropriate or should be explored. But at the very least, where the person cannot take care of themselves, or need additional guidance so that they don't harm others, that's where a conservatorship should be sought. And the family steps in and takes that role as overseeing what they need, going to the bank and making sure that their estate can cover their expenses, or making sure that the right doctors are going to them. But the court will look largely at what I think is more dominant than most of the considerations for the court, a physician's declaration. And I typically bring this with the initial petition to ensure that the court has what they need and are looking at relevant files. But with this physician's declaration, they will determine if the conservatee needs to appear, if the rights being sought are overly restrictive, or if they need to pull those back. And that's where they will work with the court-appointed attorney and the investigator to come up with a consensus and the best possible outcome for the conservator and the conservatee.
I know there's also different types of conservatorships. Can you kind of explain for the audience the difference between the conservator of the person versus the conservator of the estate?
So again, there's two types of conservatorships largely at play. There's conservatorship of the person, conservatorship of the estate, and sometimes you have both, or more often than not, you have both, conservatorship of the person and the estate. Conservatorship of the person means medical decisions. So if you have that awarded by the court, that grants the conservator the ability to make medical doctor appointments, doctor decisions, whether they take their medications, if they need to go into a special facility. That's of the person. Of the estate is for financial matters or financial authority. When you get conservatorship of the estate, you can then go to the bank, request access to their accounts so that you can use their funds to better take care of them. And then I said, more common than not is of the person and the estate. So that's where someone is seeking conservatorship of both their financial assets and their medical decisions. And those two together largely complement one another to have that full overarching authority and ability to handle every need of the conservatee.
And Adam, how are these different from power of attorney and healthcare directives that we've talked about in previous episodes?
So a power of attorney, advanced healthcare directive, as you'll see, these are very similar with the financial portion and then the medical portion. However, if you've had a power of attorney and an advanced healthcare directive, you largely won't find the need to be in the conservatorship space. You'll find yourself here if you don't have these documents in place, which means you haven't elected someone to step up, take authority and agency over your state, over your person. And so the court is going to have to do that in its stead, in the lack of or the absence of these documents, because they were not executed and cannot now be executed given the conservatee's current lack of capacity.
Adam, when somebody gets appointed as a conservator, what responsibilities immediately do they take on?
It's a great question. It's a very loaded question. They take on a lot of responsibilities. It's a high fiduciary responsibility level. And they will continue to work with the court. The court will have oversight and will want accountings and regular checkups to ensure that everything they are doing is kosher and in order. But this is a good check and balance. It's a good system the court has put in place because they also ensure that the conservator has gone through a specific program or set of rules so they understand what authority and agency they have once it's granted from the court, how to use it, and what the follow-up requirements are. So they'll have to ensure certain dates and file-by dates are met in terms of accountings and numbers. They'll have to ensure that the court is brought up to speed with relevant activity of the conservatee. And of course, if things change, those are brought to the court. But a power of attorney, advanced healthcare directive, if you're in conservatorship land, it's too late. The conservatee has lost capacity and unfortunately can't make these decisions. So we're here where the court can help make those decisions on their behalf.
And Adam, I'm sure that this is a stressful process emotionally. It's got a toll on families. How do you help your clients kind of manage that side of the process while keeping things on track, obviously legally?
It's a very draining process at times. Sometimes it's pretty smooth and quick and easy. 3 to 6 months, you can get things moving. There are other times where it's very difficult and you're entrenched with probate notes or discrepancies between the physician's declaration and what you're proposing or what the court-appointed counsel is proposing. So we work with the court to address any discrepancy, square up the probate notes so that they get their answers, they get what they need. So it is very cumbersome and clients will find themselves drained at times given how much involvement there is. There's a lot of questions from the court. There's ensuring that they comply with their powers. There's continuing to go back to court and make sure that you're in compliance and reporting accountings. It's a very heavy lifting, and the conservator who's signing up for this should understand the responsibilities before they enter this. But it's extremely important to hold the client's hand, and that's what I like to focus on. Given how long it can take, I like to make sure that I'm in readily accessible contact for that client. They know exactly where things stand, when the next hearing is, how things might look once decisions are made in terms of timelines, but ensuring they're very informed and kept up with the process throughout.
Can you share some examples of situations where a conservatorship helped protect someone's well-being or even their financial security?
Yeah, so one good example would be a client I have now. They have a mother. It's two brothers who have a mother that is a harm to herself and to others. She's had to be restrained in the hospital. She can't make decisions, doesn't know what her best interests are. So these two conservator brothers have applied and sought powers to now have their mother moved out of a hospital where she was stuck for a good amount of time, brought to the proper facility where she can get adequate care, where they can visit her, where they can make sure her level of care is sufficient, and also provide for her surplus needs. So if she needs additional comfort, they can apply for that or they can provide for that as needed. But the client has more accessibility to the conservatee and also has more authority where they can help that conservatee and make the proper decisions for him.
Adam, what kind of planning would you recommend for someone in terms of they want to avoid needing a conservatorship later on down the road? What kind of planning can help them make the difference?
Yeah, so extremely important are powers of attorney and advanced healthcare directives, which we touched on before. If you have one of those, you likely can avoid the conservatorship process. That's huge. Conservatorships are timely, they're costly. These instruments are very simple. They shouldn't be expensive. They should be very accessible in terms of finding an attorney who can do it for you, or doing it on your own. And having this in place is huge. But I will add to that, when you do an estate plan with an attorney, they will gauge what you don't know. The client doesn't know what the client doesn't know. And so it's our job to understand the breadth of their estate, how they want things to go. And perhaps a nomination of conservatorship is a relevant consideration. So if the client is older in age or getting to a point where there's some mental or physical disabilities, I will talk to the client about putting a nomination of conservatorship in place. This is a relatively straightforward, streamlined document that provides the court direction and helps them elect your conservator without having to do the excess legal work.
And Adam, for someone who's listening to this right now, maybe they've realized a loved one might need this kind of protection. What's the right way you would recommend for them to start the process?
Yeah, so what I suggest, of course, always start with powers of attorney, advanced healthcare directives, and your HIPAA release. If you're over the age of 18, get that in place. If you are beyond that point, I would talk to your family about nominations of conservator. If you have young ones, nomination of guardian. And that would be part of your estate plan. This document would complement your estate plan, essentially providing guidance to the court, if it was ever needed, who your nomination or who your guardian should be or who your conservator should be. And so the attorney, as part of their due diligence and really getting to know the client, will put these documents in your estate plan to plan for eventualities. Of course, my recommendation is, if you can get a power of attorney and advanced healthcare directive in place, to do that first and foremost, anyone over the age of 18.
Yeah. Adam, thanks for the time and breaking this all down as usual. We truly appreciate it.
Thank you for having me.
And thank you to everybody out there listening to another installment of Protecting Your Legacy with Estate Planning. Look, if you want to learn more about establishing or even avoiding a conservatorship altogether through careful planning, do me a favor, visit stonewoodlaw.com. Don't forget to like, subscribe, leave us a review and comment, or share this episode with someone who needs to hear it. As always, I'm Mike Leon. We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.